Hi, this is Bobby Fazy, attorney with Insight Law, and this topic is explaining federal estate taxes in plain English. So welcome to the IRS supermarket of life, and that's the way that we explain estate taxes at Insight Law. So pretend that, visualize that we are in the IRS supermarket and everything inside of the IRS supermarket is subject to death tax. And then let's assume or imagine that we have a husband shopping cart. I'm going to do a husband and wife situation. Husband shopping cart and a wife shopping cart. And let's say that this is the checkout counter, also known as an IRS auditor. When you check out, everyone's got to check out at some point. The IRS wants to value your estate assets, and there could be a tax due based off of the value of the assets. Then now imagine that this is the parking lot. That area over here is the parking lot, and parking lot is death tax-free zone. The goal actually is to get as many assets from inside the supermarket out to the parking lot. So in our plans, husbands always check out first in our plans. You can do whatever you want in your plans. And so we'll assume the husband checks out first. And when the husband checks out, he's at the IRS checkout counter. They will value all of the assets in his cart. So if he has a real estate, whatever the value of the real estate is at the date of death will be that asset in his cart. If it's jointly held, half of that asset value will be included in his estate. If he has an IRA, the value of the IRA as of the date of death. Bank accounts. Life insurance is a tricky one. Even though life insurance is normally not subject to income tax, if you are the owner of your life insurance policy and it's $1 million policy, guess what? It is subject to estate tax and it is included in your estate. Let's just say for argument's sake that we're shooting this in 2016. Let's just say for argument's sake that you have $5,450,000 in your cart when you pass away. The IRS person is going to ask you what you want to do. You have two options at that point. You can use your coupon. Everyone right now has a coupon worth $5,450,000. You give the IRS person your coupon. You take those assets. You take them out to the parking lot. My question to our clients is, did you pay any tax under that scenario? No, you use your coupon, we got $5,450,000 out. The second option is you could say, I don't want to use my coupon, I'm going to leave everything on the belt, leave it to the surviving spouse, and I'm going to walk out of the IRS supermarket. Question, did you pay any tax under that scenario? You should ask yourself, did we get anything out? Nothing left out, it's still in the supermarket, we didn't take anything out, so there was no tax due. So the surviving spouse in the situation, we left the assets to the surviving spouse. And our joke is, when does the surviving spouse check out? Because the husbands think it's 2 weeks later from a broken heart. But most of the times they say it's much later, much later. But when the surviving spouse checks out, let's assume that we have an estate that's worth almost $11 million. So we're talking about a larger size estate. And let's say the surviving spouse has her coupon of $5,450,000 when she checks out. She uses that. The issue is that remaining $5,450,000 that the first spouse left to the surviving spouse. Under the current estate tax laws, those assets get taxed at 40%, and that's due 9 months from the date of death of the surviving spouse. That's for the beneficiaries to pay. So the whole point of our IRS supermarket is to get double coupon days at the IRS supermarket. With good foundational estate planning, basic planning, we can shelter almost $11 million under the current laws by utilizing or maximizing your coupon. The trick is, how do you use your coupon? And it's a use it or lose it proposition. When you check out of the IRS supermarket, you've got 9 months from the date of death to either use that coupon or lose it. Now you could file a 6-month extension, but it's basically a use it or lose it type of deal that the surviving spouse normally or your trustee is going to have to elect on the estate tax returns. And traditionally, we've done that through a trust has been a good way to use your coupon because you can get a lot of protections with the trust. Attorneys will call this type of trust a B trust, a bypass trust, credit shelter trust. Our clients call it the coupon trust or the family trust. If you knew nothing other than the name the family trust, who do you think the beneficiaries of a family trust would be? Could it be your spouse? Sure. Could it be your kids? Sure. Could it be your nieces and nephews? Sure. Can it be your college roommate? Sure. Actually, the IRS is surprisingly liberal. You can structure this trust however that you want. And so that's one point or one option that you can do is utilize a trust. The other option is you can elect portability, and this is a nuance in the law. It's a new, fairly recent law, where you don't have to use the trust to preserve that coupon, but you have to fill out a fairly lengthy federal estate tax return, 706 estate tax return, and that has to be done within 9 months of the date of death plus extensions. The issue of portability, the pros and cons, that's going to be a topic for another video, but that is the basics on that. Now, with regard to larger sizes of estates, and let's say that husband in this situation had a $10 million estate, if he tried to take all $10 million when he checked out of the IRS supermarket, what's going to happen is the IRS is going to catch him for shoplifting for all assets over $5,450,000, and there will be a 40% tax due for the spouse to pay, and that's not a situation we want to be in. So what normally happens for the larger estates is that we utilize the coupon on the first death, and any excess assets are going to stay in the supermarket and stay with one person and one person only, and it can only be the spouse. I call it the Melinda Gates exception. Even Bill Gates, one of the richest men in the world, can walk right out of the IRS supermarket and not pay one dime of tax, but he can only leave it to assets to one person and one person only. That's Melinda, his wife. But you better be sure that when Melinda checks out, they'll be waiting. Okay, so we want to make sure we're using both coupons. And we leave those assets in what's called a marital trust. So as the name implies, the spouse is the only beneficiary of the marital trust. Now, we could leave those assets outright to the spouse, and we've saved the taxes, but we have a story in our firm called the school bus story, where if you hit the school bus and you get creditors, and so we want to leave those assets to the spouse in a school bus trust where it's protected from her later creditors. That's a general overview of the IRS supermarket. I hope that's been helpful for you. This has been Bobby Fazy, attorney with Insight Law.